Welcome. Hello and welcome. Welcome. Thank you for being here. Welcome to another episode of the Empowered Immigrant Live. My name is Otis Landerholm, and I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. Welcome to another episode of the Empowered Immigrant Live. Today, our topic is what is expedited removal? Who is subject to expedited removal? And so let's clarify this. This is a important topic, and so thank you everyone for tuning in right now. It's a pleasure to be here with you today. All right, remember that the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration law and to make the most out of their lives. All right, today our theme is what is expedited removal, and more importantly, who is subject to expedited removal. And my question for everybody watching is, hey, do you want to strategize? Do you want to find a way? Do you want to at least understand what your options are, what your methods are, what the best strategy would be for you to change your immigration status, to come out of the shadows, to get a green card, to get some kind of status that could change your life for the rest of time so that this whole immigration issue can be put behind you? Because if so, I'd love to help you with that. All right, my firm is on a mission to win 10,000 immigration cases in the next 10 years by 2035, and we would love for your case to be one of them. All right, as I'm talking about our topic today, which again is expedited removal, which is a very important topic. All right, as we talk about this, feel free to ask your questions. All right, and I'll do my best to answer all of them. And, you know, we're live and we're talking with people on YouTube, Facebook, LinkedIn, Instagram, TikTok. And so thank you, everyone. Welcome to our episode today of the Empowered Immigrant Live. I really appreciate each of you for taking the time and being with me here today. All right. It is March. I'm filming this. It's the 11th of March of 2025. All right. We got 6 weeks since since Donald Trump re-entered the White House. A lot of changes have happened and continue to happen. All right, the Laken Riley Act has passed. ICE is starting with its mass deportation efforts. Both the Senate and the House have approved Trump's budget. Right? Trump announced a new gold card, which in my opinion is ridiculous because there's already an EB-5 program, but that has been announced. There's a registry requirement, all right, that has been announced. All right, still no news about that, but we're waiting for that. We're expecting that. I'm not going to go through that today. In the meantime, DHS has fired its acting director of ICE. Okay, so ICE leadership is out. New leadership has been appointed. The Trump administration has also fired many immigration judges, which is nonsensical, actually, because you fire immigration judges and now you slow down your efforts of deporting people instead of speeding them up. So it's actually kind of odd, all right? But that has been, I mean, it's a conflict between the goal of speeding up deportations on the one hand and the goal of reducing the federal workforce, which is a goal also of Donald Trump and the Doge led by Elon Musk. So that's happening, and we're seeing that tension play out in immigration, okay? And part of the challenge there is if you're letting go of immigration judges, right, which is going to slow down the deportation process, what are they going to do instead? Well, it leads to our topic today, right? Because if you're going to let go of immigration judges, but you want to increase deportations, how do you do that? You create expedited removal so that you can deport people without immigration judges. Got it? Which is very, like the questions that come up is, hey, does this violate a person's constitutional right to due process of law, right? Like people ought to have the right to have their case heard by a judge who's actually trained, right? Instead of by an immigration officer who's basically a low-level employee of the government, right? So let's get into that. Let's get into that. And that's really what we're here to talk about today. And if you have got questions as we're talking, feel free to submit them. And my name's Otis Landerholm, and I'm an immigration attorney. I'm a certified specialist in immigration law by the State Bar of California, right? And I'm the founding attorney of Landerholm Immigration A.P.C. We're a law firm. We fight for the rights of immigrants, all right, out of our office here in Oakland, California, and we fight cases throughout the United States, all right? So let's get into the topic today. What is expedited removal? Expedited removal. Deporting somebody without going through a judge. This process, right, is defined in Section 235B1 of the Immigration Nationality Act. It was passed by Congress in 1996 as part of IRA, which stands for the Illegal Immigrant Reform and Illegal Immigration Reform and Immigrant Responsibility Act. IRA. Okay? Passed in 1996. Very bad law, right? My opinion, it's bad law, and it needs to change. Okay? It's also the law that creates all the unlawful presence bars, the permanent bar, the 10-year bar. All of those bars were created by IRA, which essentially means that if somebody leaves the U.S., they trigger a bar, which is why people want to stay in the U.S., even if they don't have documents. It's better to stay in the U.S. Why? Because of IRA. Thank you very much, Congress, back in 1996. Bad law, everybody. It's bad law. Okay, it created expedited removal, among other things. What is expedited removal? As I mentioned, it's a way to deport people without going through a judge. It's just by a low-level employee within the government. Okay? It's much quicker. It's much worse for our clients. It's much worse for an immigrant because they don't have the right to present arguments, right? There's no right to appeal if you are ordered deported that way. There's no hearings. There's very little legal protections. So who does expedited removal apply to? Like, who is subject to this? Who's got to worry about this? It applies to two groups of people. And this is what you got to know. It applies to two groups of people. Group number one are people arriving at a port of entry with false documents or fraudulent documents. They can be deported right then and there. Okay? Or who have committed fraud in any way, or who have been found to violate their visa or their immigration status in any way. They can be deported right then and there. Okay? And two, right, people who have already been, already entered the United States, not been admitted, but they've already entered the United States, who are caught in the U.S. and who have not been present for more than 2 years in the U.S. All right? Or who can't show evidence that they've been present for more than 2 years in the U.S. Got it? That second group is who I'm really worried about. In the U.S., entered, not inspected and admitted, right? Entered, and you don't have evidence that you've been in the U.S. for more than 2 years, right? If you're in that situation, then an officer can determine whether or not you have evidence that you've been in the U.S. for 2 years, for less than 2 years, and if so, they can deport you. No appeal, no opportunity to fight your case. That's expedited removal. Okay? Now you might say, hey, what about asylum? Hey, Otis, what about asylum? Lawyer, what about asylum? Good question, you know. If you're afraid for your life to return to your country, and if you say it while you are being detained or while you are meeting with the immigration officer, if you say that you are afraid or that you are seeking asylum or that you need to seek asylum because your life is in danger, that officer is supposed to refer you to what's called a credible fear interview, a CFI, a credible fear interview. In my office, gosh, back in the day, I used to do this a lot. I would represent clients at credible fear interviews, all right? And I would take notes and I would argue on their behalf in a credible fear interview. And then if they lost, I would challenge that denial in front of a judge. Okay? And that's happening, right? That's happening more and more, and it's going to happen even more. Okay? If you pass a credible fear interview, then you get an NTA and you fight your case. If you're denied a credible fear interview, you can challenge it in front of a judge, but if you're ultimately denied credible fear, you're deported. Okay? Once a person is expeditiously removed, they have a deport order, and it's a 5-year inadmissibility. After that, if a person re-enters unlawfully, they trigger a permanent inadmissibility. We call it the permanent bar. Okay? And that's the way it works. That's the way it works. Okay? Is that clear? Any questions about all this? I know there are questions out there. I know people are submitting their questions. That's great. I'll do my best to answer them. But before I answer them, it's like, okay, what's the point? Hear me. It is wise to have evidence that you've been in the U.S. for at least 2 years. Okay? Keep evidence of your tax returns, of your address, of your presence in the U.S. for the last 2 years. Keep them in the glove compartment of your car. Keep them on your phone. It's better to be prepared. All right? Why does that matter? It can be the difference between receiving a notice to appear so you can fight your case in front of a judge versus being deported with no opportunity to fight. And I want everybody to be prepared so that the law is in your favor. The process is in your favor. Does that make sense? That's the point. That's the point I wanted to share today. That's like, thank you. Thank you for tuning in for that. Hopefully that is useful and helpful. If it is, my best advice, hey, please take a moment, subscribe to our channel, give us a heart, give us a thumbs up, give us a wave, whatever on your platform. Thank you all so much for being here. Really appreciate each of you. All right, now I'm going to get into the questions that I see here, and I'll do my best to answer each of them. J Sky Z, all right? Skies. Is military parole still available, and do you think it will be taken away? Yes, it is still available, and maybe it might be taken away. You know, the Republicans have expressed frustration. Not all Republicans, but many Republicans have expressed frustration with the parole in place option. Okay, and so they view it as like circumventing the rightful process, which is the consular process in their mind. I view it as a great option for people who are serving in the United States military to be able to help their parents and their spouses. So I like military parole in place. I think it's a good benefit and a good service. I think it should be expanded, not taken away. But yes, bottom line is if you're eligible for military parole in place, or if you're in the military and you're married to someone who's undocumented, or if you have parents who are in the U.S. who are undocumented, like talk to a lawyer, file that case sooner rather than later would be my best advice, so that you can maximize their chances of being able to utilize that towards a green card. Okay? Good. Honey Pasino, excuse me. Yeah, thank you for being here. What is up with this March 27th motion hearing regarding TPS? Maybe you know something that I don't. Let me look at it. Let me look it up real quick. March 27th hearing re TPS. Has something been scheduled? National TPS Alliance versus NOME. Yep, there is a hearing. Okay, thank you. Complaint filed in court in the Northern District of California, National TPS Alliance versus Nome. They're challenging the cancellation of TPS for which country? I need to download these complaints. Bear with me. This lawsuit presents a challenge to Department of Homeland Security Secretary Kristi Noem's decision to deprive 600,000 Venezuelans protected by TPS of the right to live and work legally in the United States for the 18-month period lawfully authorized by her predecessor. Yeah, okay. So there's a hearing on this. Thank you. Honey Pacino, thank you very much for informing me about this. The complaint is 48 pages long. I will read it, and I will post a separate video about it. Very cool to see this is happening. Basically, what they're alleging is that the decision to end TPS for Venezuela violated the Administrative Appeals Act. Okay? I said that wrong. The Administrative Procedures Act. I said Administrative Appeals Act. Okay, the APA. And so, so that's what that is. All right. All right, Travelpedia. I have a I-140 approved through 245I. Does it offer protection, no criminal record, or leave the country? So yes, I-140s that were submitted on or before April 30th of 2001, as long as you were physically present in the U.S. on December 20th of the year 2000. That's all a mouthful, but that's the way it works. As long as you comply with 245I, you are protected by it. You are, quote unquote, grandfathered in under that old law. And now if you have a U.S. citizen child who's turning 21, or if you're married to a U.S. citizen, you can adjust status even if you entered the country without permission. Okay? You have to pay a penalty fee through 245I. That's the way 245I works. No need for a waiver. You pay a $1,000 penalty fee along with the other requirements for your green card, and you can apply. All right, my office is doing several 245I-based cases right now, and yeah, that's a good case. It sounds like a good case. You've got to make sure you still have a petitioner available to petition you, right? That could, in theory, be your employer still. But if you have a separate petitioner, that is more common, right, since it's so many years later. But yes, Travelpedia, I'd love to do a consultation with you. We can look at the situation in a lot more depth and hopefully help you through that. All right. Giggity Goo, thank you for being here, and I like your name. All right. Is anyone with an expired permanent resident card at risk of deportation? Basically, no. All right. If you have if you are a lawful permanent resident, then the fact that your card expires does not put you at risk of deportation, because being a lawful permanent resident is permanent. Okay? There are other things that could put a lawful permanent resident at risk of deportation. If you violate the terms of your green card, if you get arrested, right, of certain crimes, if you leave the country for over a year and abandon your residence in the U.S., like certain things can put your green card at risk, but just having the card expired does not put your status at risk, okay? And, unless you have a serious criminal conviction, right, which talk to a lawyer if that's the situation, but unless you have that, just renew your green card. Just renew it. It's easy, right? It's on Form I-90. You can, our office would be happy to help you with that. If you want us to do that, you could do it on your own as well. The I-90 form is nothing to worry about. Just do it well, right? And if you'd like professional assistance with it, hey, our office is here to help. Feel free to schedule a call. Okay? All right, and if there's any complication in your case, then definitely get a lawyer, right? We have seen it where somebody files an I-90 and then ends up being put into deportation proceedings, We have seen that. Very rare, but it does happen, especially when someone has a criminal record. Okay, or if there's a record of deportability somewhere. Okay, very good. And giggity goo, thank you for asking that question. Hope it was helpful. All right, the mystery solver. What do you think about I-220A? Does this release on recognizance count as being admitted? Well, so good question. It doesn't count as a quote-unquote admission, but sometimes, we've got to look at the record very carefully, sometimes there's an argument that it can count as a parole. When you're released from detention, sometimes a person can be released and paroled into the United States, a 212D5 parole. And so, but it's not, there's no uniform one answer to that question. All right, so yeah, that's my response to that, and thank you for asking that question. All right, Sam, you say hello. Thank you, Sam, for being here, and hello to you as well. All right, Shorty Short 987. Well, will you have to go to the closest safe country? You have to go to the closest safe country. I think there was more to your question. I don't see it. All right, so Shorty Short. Maybe I'll get to it as I'm going through, but I don't see really what your question is there. All right, Business Mindset. Love your name. All right, USCIS received an RFE for the I-864, I-485 200 days ago, and still nothing. What to do? I see. So USCIS received your RFE response about those two things. Is that right? And then and there's still nothing. I mean, that's not uncommon. I wish it were uncommon, but it's not uncommon. And so, you know, keep following up. You can do inquiries. You can do ombudsman requests. You can follow up to push them about your pending adjustment of status case. And if you really want to get serious about it, you could also sue the government about it. We do that through an ombudsman, we do that through what's called a mandamus, okay? But that would depend on when your original case was submitted and current processing times for your field office. We would need more information about everything there, but you could, in theory, sue them and demand and ask a judge to demand that that USCIS makes a decision, okay? All right, Cold Story, you say you have a question. Great, submit it. I'm here to help. Sam, you say, please talk about payment plans available to U visa clients. Yeah, to know pricing and to know payment plans, we do offer payment plans. All right, so that's the good thing. But to know specifics, we've got to understand your situation first. All right, so feel free to contact our office, schedule a consultation. We can understand your case. We'll give you good advice as to whether or not we recommend filing the U visa. And then we can talk through what's the pricing, you know, in your case and what would the payment plan be in your case. All right, Manny Puri. Hard to lift a deportation order after an I-130 was approved, or length of time to even be heard, question mark. Hard to lift a deportation order after an I-130 was approved? Yes, it is harder now than it was under the previous administration. Previous administration, we were getting cases reopened and terminated after an I-130 was approved. That is unlikely to happen under the current administration. Okay? Length of time to even be heard, that basically your real question there is how long does a motion to reopen take? And that depends on court and it depends on judge. So there's no one-size-fits-all answer to that, unfortunately. You know, San Francisco is much more reasonable. LA is much more slow, in my experience. Certain other courts in the country, every court's different. Every court's different, all right? So it really depends on which court issued your deportation order, all right? And we could get you that advice, be much more granular with it if we had a full consult. Okay, worst behavior 811, all right? Thank you for being here. You say, hi, what about advanced parole? Good question. What about it? What about it? Advanced parole still exists. It's still usable. All right. If you're talking about advanced parole through TPS or advanced parole through DACA, then you might want to file that sooner rather than later because those things might go away. Right? Matter of ZRZC could come back again, which, if you remember from the first Trump administration, took away the benefits of traveling on advanced parole for people with TPS and DACA, right? And so that's something to be mindful of. Kayla G415. My husband carries around my I-130 petition receipt from USCIS along with our marriage cert. Is that enough for 2 years of proof? I mean, that's good as long as the marriage and the I-130 receipt happened more than 2 years ago. You said it's from 2017. So yeah, that's good. You know, that's good. Thank you. That's a good question. That's a good, maybe have a few other things too, but I'm glad that you're going through the petition process. That's good. All right. Business mindset, yeah. Oh, I answered that question already. All right. Cindy A. entered with an H-2A in 2010, no bad record. Okay, good. So you entered lawfully on an H-2A visa. And so now the question is, well, if you get married to a U.S. citizen, if you have a child who turns 21 who's a U.S. citizen, they could petition for you so you could use that lawful admission to adjust status. Okay? And because you have a lawful admission, you will not be eligible for, or you will not be subject to expedited removal. And you have more than 10 years in the country, so in theory, you could apply for cancellation of removal if you were NTA'd, if you have a qualifying relative, right, a U.S. citizen or green card holding spouse, parent, or child who would suffer a very high amount of hardship if you were removed. Okay, so you can file things, Cindy. You would have strategies in your favor if you were ever sent to immigration court, and feel free to contact our office if that ever happens. Hopefully it doesn't. Okay, giggity giggity goo. Any direct email, how to reach out? You mean to our office? Direct email, how to reach out. I think in the description of whatever platform you're watching us on, there should be information about how to contact our office. Typically, the best way to reach out, honestly, is just picking up the phone, giving us a call. All right, you can even text us. Go to our website. You could chat with us through our website, okay? All right, so Omar Seda, I'm a U.S. citizen. Can I go to Afghanistan? I can't answer that. I can't answer that. But under U.S. law, yes. Right? So, the reason I say it like that is because I can't give legal advice about travel to other countries. Right? I'm a lawyer in the United States. So if your question is, hey, I'm a U.S. citizen, can I go to Afghanistan and come back to the U.S.? Like, you can come back to the U.S. after your trip, but can you get a visa, or do you even need a visa to enter Afghanistan? I don't know the answer to that. You know, talk to an Afghani immigration lawyer to make sure that you have your papers in order, and probably, right? But I just don't know. You know, look it up in the yeah. You'll have to do some research. It's not my expertise. It's a good question. All right, the chosen one. All right, you say N400 was denied because USCIS said I'm already a derivative citizen. So what do I do? All right. Well, congratulations on that. Right? You're already a citizen. Okay? So you have two ways to do this. One, you can just straight up apply for a U.S. passport, right? But you're going to have to show how you won derivative citizenship. It's typically through your parents, right? You must have had a green card and been under 18 when one or both of your parents became citizens. So if that's true, congratulations, you're already a citizen. And if the passport application gets denied, the other way to do it is on Form N600, which, feel free to reach out. Our office can walk you through that process. We've done it. We've won it. We've also seen pushback on them, too. So that's even though one officer might say you're already a citizen, it doesn't mean that other officers will necessarily just approve your case right away. And so that's something else that can be frustrating for people sometimes. And also, you could appeal it to the chosen one. You could appeal that if you disagree with them and you want them to approve your N400 instead of an N600. You could disagree with them, show them that they're wrong, and then win your N400, right? So that is the other option. All right, cold story. My B12, your B1, B2, I'm sorry, your visa expiry date was August of 2024. I filed asylum in August of 2024. USCIS received my case on August 28th. Oh, you're saying, okay. Okay. So for 4 days you had unlawful presence. Yeah, great. You had 4 days of unlawful presence. You're okay. All right, you're okay. Don't even worry about it. If you have 180 days of unlawful presence and eventually leave the U.S., then you would trigger a 3-year bar. You do not have 180 days of unlawful presence. You have 4 days of unlawful presence, and you haven't left the U.S. Your asylum case is going to be fine. You're in good standing. All right. If you want to contact my office to see how we could maximize your chances of winning your asylum case, please do that. But the 4 days of unlawful presence is nothing to worry about. Okay, for your asylum case anyway. You will still be eligible for asylum if you have an asylum case. If you would otherwise qualify for asylum, the 4 days of unlawful presence are the least of your worries. All right, DERV. Hello, can someone under DACA get papers through the workplace? In some situations, yes, but it's not easy and it's not intuitive. You would need to talk to a business immigration lawyer about H-1Bs, E visas, L visas, all of the different workplace visa options and requirements to see if the job that you have and if the education and degree, master's degree, bachelor's degree, whatever degree is a quote-unquote specialty occupation, etc. You would need to do that research. But yes, in some instances, someone under DACA can get papers through employment. Okay, worst behavior 811, will it be taken away? What are you referring to there? You asked me a question earlier. Let me go back and look. What about advanced parole? Okay, got it. Will advanced parole be taken away? Yes, possibly. We don't know, right? Lots of things can happen. The real question is advanced parole under DACA and TPS. That is what was that's what was challenged under the first Trump administration. All right, not advanced parole, for example, through a pending I-485. So it depends on your situation and your status. And we haven't received announcements that it will be taken away or anything like that. So we're just, if we had a crystal ball and we could read the future, then we could know. We don't have that. So if you're wanting advanced parole, take action and take steps towards it. Like apply for it. All right, the mystery solver. Is a Cuban immigrant with an I-220A prima facie eligible for an I-485 under the Cuban Adjustment Act? I don't know. That's a good question. Yeah, I don't know the answer to that. I'd be happy to research that, but that would require actually you coming in and talking through all the requirements for a Cuban adjustment, including that you've been physically present in the U.S. for over a year and that you're otherwise admissible, etc. And so if you'd like to do that, feel free to contact my office. We could research that for you. All right, ERI. If I want to get married and fix my fiancé papers with a K-1, but I have a conviction, can I still fix her? Okay, so you're a U.S. citizen, is what I'm understanding by this question, right? You are a U.S. citizen, is what I'm understanding, and you want to get married and fix papers for your fiancé through the K-1 process, but you have a conviction? Okay, I got that. So typically under immigration law, typically the U.S. does not care if the U.S. citizen has convictions. They only care if the immigrant has convictions, with some exceptions, and that was a change in the law called the Adam-Walsh Act, and you could look into that law, and if like there's certain serious violent or sexual crimes that have been committed in the past, then sometimes you're not going to be eligible for that petition. 95% of the time you are fine, right? And the best way to know would be to do a full consultation. We can look at the record and we can give you that advice. But like if it was a DUI conviction, then you're going to be fine, all right? If it was a theft conviction, you're going to be fine. If it was 95% of the types of criminal convictions out there, and you're a U.S. citizen, you still have the right to file a petition, right? So anyway, I hope that's helpful. Claudia, tengo 330 días esperando respuesta en el I-485, asilo aprobado. ¿Cuánto tiempo tarda la respuesta? So I'll say that in English. I have 330 days waiting for my I-485 based on asylum. My asylum was approved. How much time do I have to wait for the response? So you're not quite at a year yet. And so, okay, so you have already submitted your I-485, it sounds like. So, you know, I don't know which field office you're filing in. I don't know the precise like processing times at your field office for this type of I-485, but it shouldn't be too much longer. You know, give it another 4 or 5 months and you should be good to go. You know, some field offices are taking up to 2 years for asylum-based AOSs. Other field offices are down to about 8 to 10 months, right? And so it's like, okay, your case is pending and it's in process, and I'm glad for that. And as long as you don't have any other inadmissibility or criminal record or anything like that, you should be approved. If you got it through asylum, it's typically a more straightforward adjustment process than others. Okay? Everybody, thank you for tuning in right now. All right, thank you for tuning in right now, and I hope this content is useful. My name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. It's 10:53 in the morning. I have 7 more minutes, all right? I'll do my best to answer a few more questions, and then we'll wrap up for today, okay? So, Taylor, what if there was malpractice in my case that resulted in a 3-year ban? Anytime there's like attorney malpractice in a case, talk it over with a better attorney that can really request all the records, review them carefully, and see if you might be eligible for a motion to reopen. All right? My office just last week, well, 5 months ago, filed that type of motion to reopen. All right? Then in December was denied that motion to reopen. Then we appealed. And just last week, we won our appeal of that type of motion to reopen. All right? So when there is attorney malpractice in the past, sometimes you have arguments based on that malpractice to reopen your case. It's really difficult to do. All right? But you got to know that sometimes that exists. Okay, so Taylor, thank you for saying that, and I hope that's useful and helpful. All right, Harleen Cower, I have my citizenship on hold for more than 2 years. What should I do? Have you already been interviewed about your citizenship? Because after the interview, the government has to issue a response within 120 days, or you can sue them. All right? And if your case is this long pending, you might be able to sue them anyway through the mandamus process. I think it's, you could at least do inquiries, potentially an ombudsman request, and then file that lawsuit. Okay, because that is a long time. That's outside of normal processing times. Just be mindful, though. Sometimes you push a citizenship case and there's problems they find. So anyway, so really, but you can do it, and you can push them to issue their decision if you're tired of waiting. All right, Kayla G415. Let's see. Do you recommend I add additional proof periodically to the unsolicited evidence portion of my USCIS portal petition? Okay, my answer is no. All right? File your case with strong evidence and then do not touch it again. That's my advice. That's the way we do it. All right? Don't touch it again until you have an interview or whatever. Every time you touch it, it could just cause additional delays, cause additional whatever. Like, let them issue their decision. All right. Winnie, hi there. I got my 19-year green card. There's no such thing, by the way, as a 19-year green card. I got my 19-year green card September 18th, 2024. Can I travel internationally? Thank you. If you have a valid green card, yes, you can travel internationally as long as you haven't been in immigration court and you don't have a deportation order against you. If you have those things, you can still travel. You just ought to first terminate those court proceedings, okay, so that you don't have problems when you re-enter and Border Patrol wants to look it up, cause problems for you. But yeah, a green card is a travel document, all right, so you can travel and you can re-enter. Just don't leave for more than 6 months, 180 days, all right, keep it shorter than 180 days. And no arrests, don't violate any law while you're outside the U.S. or ever, right? Okay, Fernando, can a police report help with a VAWA case? Yes, it can, but it can also hurt a VAWA case. You got to read the police report carefully and have an attorney really look at it. If it's a strong police report, it can help your VAWA case tremendously. If there's like an error or a problem or something misworded in the police report, it can undermine your arguments, okay? So there's no one-size-fits-all answer to some of these. Okay, so Sabrina, my lawyer gave me a paper with a statue stamp on it, and he told me it's to go out of state to work. Can I? I don't know. I don't know without really looking at it. I'd be happy to really look at it. Yeah, I'd be happy to really look at it. I'm trying to think. Like, could it have been an I-94? Could it have been a stamp in your passport? Like, what kind of stamp might that be? There are plenty of stamps that have, like, the Statue of Liberty on them. It's not about the statue. It's about what the stamp says. And if it was a stamp issued by the government, then maybe you are currently in valid immigration status. Okay? So I don't know is my honest answer. I'd have to look at the document to give you advice about it. All right, Winnie, I got my 10-year green card with marriage on September 18th, 2024. Oh, okay. Yeah, you can travel. Congratulations. Have a nice trip. Just don't be out for more than 18 months, for more than 180 days, more than 6 months. And if you have any criminal record, talk to a lawyer first. Or deportation order, right? If you've ever been in immigration court before, talk to a lawyer first. All right, SR, I see your question. I got PD in 2013 due to my asylum case. Should I be concerned? I mean, in theory, PD could be rescinded. You could be put back in immigration court. If you're put back in immigration court, you ought to still be eligible to fight your asylum case, right? So it's a lot better. You're in a better situation than a lot of folks. All right. Mr. Diawara, good to see you here. You say very useful information. Thank you for that. All right. Shodri, I see you here. Thank you. Are asylum interviews fast? If I file now, no, they're horribly, horribly slow. They're incredibly backlogged. Okay? Should someone be worried about getting deported if he gets military parole in place and then a pending AOS? If you get military parole in place and if you have a pending AOS, no, you should not be worried about being deported unless your case gets denied. All right? Like, good for you for going through that process, and congrats if you got military parole in place approved already. Okay? Taylor, my lawyer ghosted us after a denial. That's unprofessional. All right? Maybe you want to work with a different office. Okay? Samira, is the travel ban coming soon? Probably, right? You guys have been seeing the news? Probably. Be mindful of that. All right? In the first Trump administration, travel bans came in week 1. All right? Maybe even, I think even on the first day, there was an initial travel ban. And that has not happened this time. There's been a bunch of other things that have happened, and so we're going to see what happens with the quote unquote travel bans going forward. All the tariffs and everything else that's happening is crazy too. Keep watching the news. All right, my last question. Alex, I just got my green card approved last month. Is it safe to travel outside the country? Congratulations, you got your green card approved. Huge congratulations for you. All right. And as long as you don't have a criminal record, and as long as you've never been in immigration court, no deport order, congratulations, you should be free to travel outside the country. Just don't go for more than 6 months. Keep it less than 180 days. All right? Talk to your lawyer first if you have any criminal record or immigration court record. Okay? Benji, should someone be worried about getting deported if they have military parole in place and pending AOS? I answered that. No, you should be good to go. Carla, you're really my last question. With the new administration, will it be more difficult to apply for residency through a U.S. citizen child? Not necessarily. Not necessarily. All right. If you have a U.S. citizen child and if you entered lawfully on a visa, then no, you should be good to go. All right. The law is still clear for you. That's all I got, ladies and gentlemen. Thank you so much for being here. I'll share something with you that I'm going through. I'll share just something with you right now, okay? My father's birthday is today. It's March 11th of 2025. 1 year ago today, I got on an airplane. I flew up to Washington State. I had dinner with my dad, all right? My sister was there. We all went out to a really nice dinner for him. He celebrated his 70th birthday, all right? In June of last year, so right now it's March of last year that happened. In June of last year, my father passed away. He died, okay? He died of cancer. He didn't, when I was there a year ago today, birthday party, celebration, he was fine, everything was good. All right? Within 5 months, everything changed. Isn't it crazy how everything can change? Just like that. Like it really can. Life is short. Change is certain. It will happen. All right? Take action, folks. If you want something different for yourself, if you want something different for your future, if you want something different for your life, take action, go for it, make it happen, because I promise you, life is short. All right? And I just wanted to share that. And I really appreciate each and every one of you for being here. Like, thank you. Thank you for being here. And if this was useful, if this was helpful, please subscribe to our channels, whether on YouTube, Facebook, LinkedIn, Instagram, TikTok. Like, just subscribe, right? We're here to help. We'd love to help. We send information. We do these live sessions twice a week, every week, English and Spanish. Subscribe, all right? And if you have an immigration case that you think our office could help you with, or that, or if you want to understand what your options are or whatever, please feel free to reach out. We're here to help. We'd love to help. All right? Thanks a lot, everybody. Really appreciate you. My name's Otis Landerholm Immigration, A.P.C, where we fight for your American dream. Make it a great day, and we'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot, everybody. Take care. Bye-bye.